Who would have thought a simple loan would turn into a living nightmare? A transatlantic tussle happened between a state and a bank for a decade, and it became the first ever case to reach the United States Supreme Court. Today we're briefing Van Staphorst v. Maryland. This is Kleo Legal. Let's talk law and reason. The year is 1781. There is no such thing as the United States of America yet. There are only 26 British colonies proudly located on lands belonging to indigenous people in the Western Hemisphere. There are Christian and atheist colonizers and slave owners, ironically known as patriots, who lived in 13 of those colonies. And they have lost their with the British. I mean, by the time the facts of this case pop up, the American Revolutionary War has been raging for 6 years. I'll talk about the American Revolutionary War in a separate video, but for this video, we're gonna focus on the fact that the colonies are going piss poor broke. War is expensive, and by 1781, the province of Maryland was starting to feel the pressure. But that's where this energetic whippersnapper by the name of Matthew Ridley comes in. You see, Maryland authorized Ridley to travel to Europe to secure a wartime loan. Maryland needed the funds so badly that it agreed to honor any loan Ridley made on its behalf. Obviously, Ridley was supposed to get a loan that didn't violate any of Maryland's rules and standards, but any loan? Really, Maryland? Ridley sails to Europe with all this unchecked power. But in 1782, Ridley finally started serious negotiations with two Dutch brothers, Nicholas and Jacob Van Staphorst. The Van Staphorsts were partners in an Amsterdam bank that was trying to beat out its competition by investing in the new American government. But more importantly, the Van Staphorst brothers were hoping to branch out into the highly profitable tobacco market. The Van Staphorsts strike a deal with Ridley, which boils down to this: we'll loan Maryland the money it needs if Maryland agrees to pay us back in tobacco every year for 10 years. Oh, but that's not it. Maryland must let us buy its surplus tobacco at a discount each year. Ridley was like, it's a deal. Maryland's gonna love this. Maryland was like, you're loud and wrong, you insufferable scrub. You see, the problem was that the war was coming to an end, and the Van Staphorsts wisely recognized that the price of tobacco was going to skyrocket. You know how investors say, buy when it's low, sell when it's high, and pocket the difference? Yeah, that's what the Van Staphorsts were doing with this deal. But Maryland was getting the short end of the stick, if you think about it. Not only would Maryland have to get expensive tobacco in order to pay the loan, Maryland would also be losing profits by selling its extra tobacco to the Van Staphorsts at an extremely lower price than the market value. Seeing the clear disadvantage in this deal, you'd think Maryland would be like, get someone else to do it. But no, Maryland approves the deal in January 1783. Mind you, Maryland's leaders didn't even read the contract until 4 months later in May 1783. And when they read the contract, that's when they realized just how bad the terms were for them. But by then, it was too late to back out. Now, when Ridley finds out that Maryland is waiting to jump him, he tries to convince the Van Staphorsts to get rid of the buying tobacco at a discount part. And the Van Staphorsts refuse. So Maryland tries to convince the Van Staphorsts to accept money payments instead of tobacco. And again, the Van Staphorsts refuse. So now Maryland's heated, and Maryland's leaders are like, we're not paying this loan back. Maryland argues that the Van Staphorsts had not done their half of the deal on time. Remember, 1781, Ridley was sent to get a loan because Maryland needed money to fight a war. The Van Staphorsts had allegedly only sent a partial amount during the war. Now it's 1783. The war is over. And Maryland's like, I know you're not talking about accountability. Where were you when we needed you? Of course, the Van Staphorsts feel like they're getting cheated because Maryland did sign a contract without reading it, and the Van Staphorsts did send money. So both sides enter arbitration to see if they can iron out their differences. Did it work? Well, the answer is no. In 1790, Maryland received a summons to appear before none other than the United States Supreme Court. In a separate video, I talk about the creation of the United States Supreme Court. But what I want to emphasize is that this case, Van Staphorst v. Maryland, was the first case to ever reach the United States Supreme Court's docket. And this was a big deal. Foreigners were suing estates in a brand new country. Would the court be biased against foreigners? Would the court be tyrannical against its citizens? Would the court yank away the autonomy that each colony, including Maryland, fought so hard to get? This was the Supreme Court's chance to show the country and the world that it was to be taken seriously. Not surprisingly, there was some delay in moving the lawsuit forward. Some witnesses had died, others lived in Amsterdam, and depositions were slow. But that's when Maryland made a move I don't think anyone saw coming. Maryland reached out to the Van Staphorsts again, this time willing to do anything it could to settle. You have to remember, the colonies were sick of outside entities having control over their citizens and internal affairs like Britain did. So Maryland was arguably trying to avoid giving the Supreme Court, which was located in Philadelphia, a say over Maryland's affairs. It's up for debate whether Maryland knew they would be defeated in court or wanted to protect their state sovereignty. In 1792, the parties settled. Maryland would give a certain amount of its stock in the United States government to the Van Staphorsts to cover the loan and damages. And just like that, Van Staphorst v. Maryland, the mother of all cases, disappeared from the court before oral arguments. In a way, both sides dodged the bullet of being the Supreme Court's first experiment. But both parties arguably relinquished something more valuable. 10 years of their time, their reputation abroad, and a relationship that could have been stronger. One has to wonder, who really won in the end? And was it worth it? If you like this case brief, please subscribe to this YouTube channel and donate to Kleo Legal. There are also more ways to enjoy Kleo Legal on the go. Just check the description box below. Thank you for watching, and until next time, stay legal and stay reasonable.